And now I would like to ask Mr. Jacob Werksman, Principal Advisor and Lead Negotiator of the European Commission's Directorate General CLIMA, to please have his presentation on the emerging role of citizens and the courts in defining climate justice.
Oh, thank you, Shaba, and thanks very much to the organizers for inviting me to say a few words. And it's interesting to hear that I may have to make up maybe some time and also some substance for my colleague Clara, who indeed is incredibly busy in carrying out her duties with the Commission Legal Service. Let me start where the last speaker left off, which I believe was a sort of a passing critique of what she referred to as the state-centered paradigm of the international negotiations, which is where I spend most of my time and where I'll bring some perspective from the international negotiations currently under the Paris Agreement, which is of course a treaty-based regime involving sovereigns, which for the more than 30 years has been trying to answer at least some of the questions that underlie the discussions that we've been having today. And to anticipate a little bit, an impending confrontation between that treaty-based system of producing law and now what the international courts are beginning to contribute to our understanding of what states' responsibilities and rights are to prevent dangerous climate change. So climate justice in itself, I would say, is a bit of a contested term. Climate rights are not fully defined, though as we've been hearing from previous speakers, we are in a very rich process of giving them further definition. But if we look at the way in which the Intergovernmental Panel on Climate Change, the IPCC, that brings us all the insights that we need from science to tell us the direction that we need to move to prevent dangerous climate change, they have also picked up this concept of climate justice in trying to pull together the results of peer-reviewed literature to help us better understand what justice might mean. Climate justice certainly is, in a way, the answer to the question of what is a fair and equitable recognition and realization of the respective rights and responsibilities of actors to prevent dangerous climate change and to help those that are being affected by dangerous climate change. It is what I believe the International Court of Justice will be exploring in the context of its advisory opinion, the answer to the question of what essentially is the duty of care of a government in preventing dangerous climate change, in working with others to do so, but also to help those that are being affected by climate change that may have been caused in part by the lack of action by a particular state or group of states. The IPCC kind of breaks down the concept of justice into different areas, which I think are helpful to better understand how it is that the treaty regime can help contribute to the development of climate justice. It speaks to procedural justice. How do we provide access to the decision-making processes, access to information, access to dispute settlement, and other forms of conflict management to those people that are most affected. So procedural justice. The IPCC speaks of distributive justice. How can the rules that we put in place help to better define and to rationalize states' responsibilities to address climate change? It speaks of restorative justice. So once the impacts of climate change have an effect, how can the rules of justice help provide relief or remedy to those that have been harmed by climate change? And it talks to the theme that we've just heard explored in great depth of intergenerational justice, given that the only actors involved in these systems are those that are alive today. How can they address the concerns that may be born in the future? The IPCC also recognizes that we talk about justice as between sovereigns. So how can our international negotiations generate fairer, more just, more equitable relationships between sovereigns in terms of their duties and their responsibilities? And to a lesser extent, but increasingly so, it's trying to address the very important relationship that we've heard in the context of human rights about what it is that we mean by justice between sovereigns and the people over whom they have jurisdiction. So has the Paris Agreement helped to deliver climate justice, to deepen our understanding of what it might mean? Well, treaties, of course, address justice primarily amongst sovereigns. And this immediately delivers us a structural problem in terms of how a state-to-state system operating under the rules of multilateral negotiations and multilateral diplomacy can give space to the expression of rights and responsibilities, particularly with regard to the rights and responsibilities of individuals and communities. There is a structural problem here in that the state-to-state system doesn't allow individuals or communities to participate significantly or meaningfully in the design of international rules. It is a negotiations amongst and between sovereigns. But I think there's an important additional structural problem within the multilateral system under which agreements like the Paris Agreement are negotiated, in that in an effort to provide justice, it may thwart the delivery of justice. And what I mean by that is that the multilateral system starts with the notion that all sovereigns are equal. And this is an effort to balance power between the larger and the smaller members of the international community, the richer and the poorer states, those that have more power and those that have less power. It also leads to decision-making rules based on consensus, and the UNFCCC and the Paris Agreement have a particular structural flaw in that the parties have never agreed to any rules of procedure that allow for decision-making other than by consensus. And so this very inclusive way of structuring decision-making, which has its basis a sense of a need to deliver justice through equality and access and inclusivity, also means that it produces decisions that tend to drift towards the lowest common denominator. And if what you're seeking is justice in the context of an urgent need to address a problem, this kind of decision-making is not necessarily helpful. It can tend to thwart urgency of action, to protect the status quo, both among sovereigns, but also between sovereigns and the people to whom they owe responsibilities, rather than delivering the kinds of clear rules that are necessary to sort out disputes and to address the legitimate concerns of those that care about climate change. So nonetheless, I think that we have generated some important principles and some important goals and some important institutions at the international level that can help to guide us towards a greater degree of climate justice. The most obvious of these from the Paris Agreement are the commitment by the international community to avoid dangerous climate change by preventing global average temperature rise beyond 1.5 degrees. That is a very important commitment that we've made under Paris, that we've refined since 2015 to really focus on avoiding 1.5 rather than allowing as much as a 2-degree average temperature rise. We have also recognized, as Mr. Popov said in his opening comments, the need to create collective goals in terms of the delivery of climate finance. And that finance should largely flow from the wealthier countries to the poorer countries. And then it needs to address cutting emissions, as well as preparing for the impacts of climate change, and most recently, to include funding for what we call loss and damage. So what you might call that essential element of restorative justice as well. So these collective goals, by becoming more and more ambitious over time and a bit clearer over time, do carry the potential to help address distributional and restorative justice. But unfortunately, they continue to be goals that are collective in nature. They don't provide the fundamental answer to the question, what is the duty of care of any individual state, whether it's Portugal or Switzerland, or a party like the European Union, in achieving 1.5, a limitation of 1.5, achieving an essential level of climate finance that can help poor and vulnerable countries address the challenges of climate change. So the goals and the institutions that we've delivered are helpful, are useful, but they aren't precise enough or empowered enough in the way in which they are framed to give a great deal of confidence that on their own, they're going to deliver climate justice. The international negotiations have also produced a number of very important principles, some of which have been already cited today. At a sovereign level, we have the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances to give it its full reading. That's supposed to help us to partly answer the question, who has the greater duty of care, the priority duty of care in terms of responding to climate change. And this points us to the development of further basic principles, such as that it is the developed countries that have the greatest historical emissions that should be taking the lead in cutting their emissions, but also in providing support to developing countries that are particularly vulnerable. It also increasingly has included the results of the international negotiations has included reference to climate justice in particular, the concept of just transition, and increasingly is making references in its decisions of the importance of human rights in addressing the climate change challenge. But as I said, the big challenge that is left ahead of us is that the goals remain collective. The principles that I've just described are highly contested in terms of how you would apply them in a specific circumstance. In the year that we're in now, in 2024, we're having big debates, for example, as to whether the countries that were considered developing in 1992 that have grown in terms of their wealth and their emissions since then should now begin to bear also a fair and equitable burden in terms of delivering climate finance. We're trying to get countries like Singapore or Korea to step forward, perhaps even China, to reflect that they have a role, even in the context of applying the CBDR RC principle in stepping up in terms of leadership as well. So the principles are highly contested, and the institutions that we've developed, for example, we have created over the past 2 years a fund for responding to loss and damage that is designed to help channel funding to communities and to countries that are experiencing the impacts of climate change. Those institutions that we've created are not terribly empowered to deliver those results. They still depend upon the generosity of donors to provide the resources and all the inefficiencies of the international decision-making system to decide where to invest those resources. So as a result, overall, Paris has not yet defined the substantive duty of care necessary to define and rebalance an understanding of what climate justice should mean between sovereigns or between sovereigns and the people over which they have jurisdiction. What it has done, and this will become clearer and clearer in the course of the International Court of Justice taking up this advisory opinion, has put in place what we call a series of duties of conduct on states. So the text of the Paris Agreement makes a clear connection between that 1.5 goal, the overall goal that we've committed to, and the nationally determined contributions, the targets that countries have to come forward to contribute their fair share in delivering that goal. That's not a specific substantive duty of care. It doesn't say specifically what the European Union or what Switzerland has to do to prevent dangerous climate change, but it does create a procedural obligation for them to look at the science, to take that science seriously, view it in the light of that 1.5 degree goal, and come up with their nationally determined contribution to providing that solution. These obligations of conduct, I think, will be being explored with some depth by the International Court of Justice in delivering its advisory opinion. So essentially, the Paris Agreement points its finger back to each state to make those decisions as to what they feel they are obliged to do in the context of climate change. Paris sends a relatively weak signal, in other words. But what we have seen, I believe, is various national jurisdictions responding to that weak signal through the legislative process, but now, as we've heard over the past hour or so, through the actions of courts as well in interpreting these rather vague guidance from Paris into what it is that specifically states must do through their national actions. And we believe in the European Union at the regional level, the European climate law, which makes a very explicit connection between the Paris Agreement goals, the Paris Agreement ambition cycle, and what we need to do next in terms of coming forward with ambitious climate targets, is one example of that. It's being reflected not just in the level of ambition of the cuts that Europe is requiring of itself in responding to its obligations under Paris, but also in the way in which we're interpreting the principles of just transition. We now have put in place funds at the regional level that will help local communities deal with the costs of transitioning away from fossil fuels and ensuring that they have access to the benefits of that transition. And increasingly, we are seeing our national courts interpreting our obligations under Paris and our obligations under climate law to force member states to move more rapidly in reducing their emissions and essentially, as I say, amplifying those signals to Paris into real world legislation, real world policy. I'll make one aside, which is that there is a space in which I think Paris is delivering some very specific rules that have to do with empowering people in the context of climate policy. And that's under a provision that has established a mechanism for allowing and enabling the United Nations essentially to certify projects and activities that will generate emissions reduction units for the purposes of those units entering into international carbon markets. So this is a context, and it's a very unusual context for a multilateral treaty-based system where essentially the parties are acting directly as regulators. They're stepping into a particular market, the carbon market. They are setting standards for the carrying out of activities that are happening in the real world and at the local level in a way that will have an impact on local communities and indigenous peoples, for example. And in doing so, it's setting binding and specific standards that are both procedural and substantive in nature. So it is requiring that human rights and the rights of indigenous peoples are respected in the context of carrying out activities that will be certified by the UN. And it has very recently approved a complaints procedure that will allow those local communities to challenge whether a project should be certified for the production of offsets. So that's that set of standards and that grievance procedure that's put in place, I think, is an example of how it is that a multilateral system governed by these structural challenges of consensus-based decision-making doesn't always necessarily have to produce a lowest common denominator outcome. Anyway, into this space that has been left open by the Paris Agreement in terms of a lack of specificity of what countries should be doing to fulfill their duties of care, are now stepping in international courts. And we've already had some references to the role of human rights courts. We haven't had a great deal of discussion yet about the role of the International Tribunal on the Law of the Sea, which has just issued an advisory opinion that is relevant to this issue. And some have referred to already of this international advisory opinion that will be coming from the International Court of Justice as well. Procedurally, I would say that all of these processes are clearly more open to the engagement of local organizations, local communities, and individuals in hearing their interests than the multilateral treaty process. So they will at least help address that gap in international lawmaking. And if you look at the stories behind how it is that the International Court is taking up this question of what states' responsibilities are, you'll know that the origins of actually go back to a very grassroots effort by a group of law students in Vanuatu, one of the vulnerable small island states in the Pacific, that through their activity persuaded their government to take this case, this issue to the General Assembly, and framed the case in such a way, the questions in such a way that made it very hard for any sovereign in that context to say no. We don't need an answer to the question of what states' responsibilities are. We don't need an answer to the question of where justice can come from. So it was a result of that, in a somewhat indirect way, that the voices of local communities were heard and are now being heard quite directly, I would say, in the court's deliberations on these advisory opinions. Now, these advisory opinions, as others have pointed out, are advisory. They are the result of non-contentious procedures that can't resolve specifically what any particular state's duty of care is in the context of climate change. But there is hope that this structural opening to concerns coming directly from the bottom up, but also the fact that these questions will be put not to 192 sovereigns, but rather to 15 international judges, that although they represent sovereigns in a way, will be applying a very different set of criteria and decision-making rules when they are being asked to answer these questions than you would find in a multilateral negotiation. That might open them up to the opportunity to be much more precise than treaty-based decision-making is. We would expect them, for example, to provide interpretations of the Paris Agreement that are more precise than you may be able to get by asking the head of delegation from the EU or the head of delegation from China or the United States to agree on what Paris means in a particular context. So that will hopefully add to our understanding of what international law has to say about climate justice. But probably more importantly, they will bring in into this space not just an interpretation of the Paris Agreement, but also interpretations of the rules of customary international law and potentially human rights law as well, when they are trying to answer the questions of what is a state's responsibility to address climate change and what happens in a circumstance if states fail to do so in time. I think you can see from the submissions that sovereigns have made in trying to shape the opinion of the International Court in delivering this, that they are overall being very conservative in terms of what they're asking of the court. If you look at what the EU has asked the court to say, we essentially want it to acknowledge that if you are looking for what international law tells us a state's responsibility is, the primary source that you should be looking to is the Paris Agreement, because that is the clearest reflection of what states have consented to be bound by in this context. It isn't a single treaty frozen in time. It's a treaty that gets updated in terms of states' interpretations of what their obligations is on an annual basis, which with each meeting of the Conference of the Parties, we get a clear understanding of what 1.5 means. That we have to, for example, transition away from fossil fuels, and we have to do that in particular ways. We are elaborating further about what just transition means for the international community, et cetera. So yes, Paris is the first and foremost source of law in this context, but don't look at it simply as a reading of a treaty in its words alone, but look at it as it is. Its interpretation is evolving over time, and I think you can see from the submissions that are coming from sovereigns that we are preferring that it is the Paris Agreement that is the main source of understanding states' responsibilities, rather than these more broadly stated principles of international law that emerge from custom. So the duty to prevent harm, the duty to ensure that one state's activities don't cause harm to another state's populations or territories are important principles of customary international law, but we're not inviting the court to step in to interpret those principles in such a way that would profoundly change the way in which the states themselves understand them under the Paris Agreement. So I think that I'm not expecting something terribly revolutionary out of the International Court, but because it does have an opportunity to listen to voices other than to states themselves, and it does have the ability to express judgments that will, I think, allow to get past this structural challenge that leads us to the least common denominator. I think we are hoping that we will, from that advisory opinion, have a better sense of the limitations of a state's discretion. I think what the court in the European Court on Human Rights referred to as the margin of appreciation is in fact been narrowed by the subsequent interpretations of Paris, but also by the appropriate interpretations of what customary international law does in terms of limiting states to taking actions that are respectful of their obligations to other states, but also to the global commons. So I'm going to stop there. I'm not exactly sure what Clara would have said, but we've worked very closely with the Commission Legal Service in developing our submissions to the ICJ, and so hopefully I will have covered at least some of what she might have touched upon in her remarks. Thanks.